Well, I predicted this in my book, Get Trump. I knew that these district attorneys and attorney generals campaigned on the pledge to get Trump. These are Democratic district attorneys and attorneys general. And now they are prosecuting. Forget about the fact that he's the first former president to be prosecuted. He's the first presidential candidate to be prosecuted. And he's running against the head Democrat in the world, obviously, President Joe Biden. And when a popularly elected Democratic DA who swore to get Trump is going after the man running against essentially his boss, the chief Democrat, he better have a slam dunk, ironclad case. And I have to tell you, I haven't seen the indictment yet, but based on what I've seen, this may be the weakest case I've seen in my 60 years of practicing law. So this is a great danger to American democracy and the rule of law. And I hope that Americans and people all over the world will read my book, Get Trump, as a way of saying to Bragg, we're holding you accountable. You may not be held accountable in New York, where everybody votes against Trump, but we're going to hold you accountable around the country, in front of bar associations, and in front of the court of public opinion, because what you've done endangers the rule of law. You know, today it's a Republican Trump, tomorrow it could be a Democrat, day after tomorrow it's your Uncle Charlie and your niece, and this involves all Americans. I'm a liberal Democrat. I voted against Trump twice. I have no idea who I'll vote for this next time, but it has nothing to do with politics. It has everything to do with the fact that the Constitution requires a presumption of innocence. It doesn't allow targeting of people. And Nancy Pelosi announced today that, no, Trump has to prove himself innocent. No, not in America. In America, an indictment doesn't mean anything. It's just a piece of paper charging somebody with a president with something. But I think every American has to be very concerned about what happened yesterday. And as we know, there was a thought perhaps to go after a former president named Richard Nixon. And President Ford did the right thing. And he said, no, we don't do that in America. And he endangered his own presidential reelection. I had dinner with President Ford some years after that. And he said that was the most important and principal thing he did during his presidency, preventing a precedent from being established that you go after former presidents criminally, even though there was very strong evidence that he had obstructed justice and paid bribes. Here, there's nothing. Here, there's a non-disclosure agreement. Thousands of them are written every year. Nobody in history has ever then put on his corporate form, oh, the reason I paid the $130,000 was to make sure my wife and family doesn't learn about the fact that I was accused of having an adulterous affair with a porn star. Why would anybody ever pay for a non-disclosure agreement and then disclose it? So never in history has anybody been indicted for that kind of Mickey Mouse crime. And then they stitch it together with a federal felony to try to make it a felony. That's not the way criminal justice should operate. You know, Thomas Jefferson once said that for a criminal statute to be constitutional, it has to be so clear that a person who is reading it while running could understand it clearly. Now, I'm going to read this indictment while sitting with 60 years of experience, and I can bet you that I will not understand how they could make a state felony out of a fake misdemeanor and a fake federal felony that nobody else previously wanted to prosecute. This was a decision made by one person, obviously the elected district attorney, and he knows he can win this case in New York. Do you remember what happened to me on Martha's Vineyard? I defended President Trump in front of the United States Senate on constitutional grounds, and I lost all my friends on the Vineyard. My wife lost her friends. My children lost their friends. Everybody turned against us because I had exercised my and his constitutional right to defend himself. If you just multiply that tenfold, that's what would happen to a judge in New York or a juror in New York who acquitted, who applied justice, actual justice to Donald Trump. He would never, ever again be part of New York life. He cannot get a fair trial in New York City, and that's why Bragg went after him. Bragg doesn't want to lose this case. He doesn't care if it's reversed on appeal. He'll blame it on the judges. But he doesn't want to lose it in front of a jury, and he probably won't lose it in front of a jury. As they say in New York, a grand jury will indict a ham sandwich, but in New York, when the name of the ham sandwich is Donald Trump, a petty jury will convict him as well. And even though he has very good lawyers, I think the likelihood that lawyers can persuade New York jurors to allow Donald Trump to walk away free and run for president and be reelected is very unlikely. You can't indict him if he's not in New York. Well, when do you think they indicted him? They indicted him when he was in Florida. So the fact that they indicted him when he was outside of New York means they could have indicted him any day during the 7 previous years, and they didn't do it. And I think they blew the statute of limitations. Now, they will argue that no, because he was out of New York, the statute provides that the statute of limitations tolls. But it's a nonsense argument in light of the fact that they did indict him while he was outside of New York, something they could have done for years. The reason they didn't indict him over the last 7 years, previous prosecutors looked at the case and said there's nothing to it. We're not going to indict him. Those were legitimate, neutral prosecutors. And then you get a partisan political guy, and he says, no. The first 2 years, I said I didn't think there was a case. In fact, 2 of his assistants quit over that. But I don't know. Did he get calls from George Soros, from other contributors? I don't know the answer to that. But he obviously had pressure put on him.
Yeah, did he get blackmailed?
Well, I don't know anything about that. I don't know what he'd be blackmailed for. He seems like an honorable and decent man and a good lawyer, and he had a good reputation. But you know, when you're caught up in the political winds and you're in New York City where nobody has anything good to say about Donald Trump, I don't mean nobody, but people, voters, don't. If you wear a MAGA hat in New York City, you know, you're going to get hit by a bike, or you're going to get, attacked and physically attacked.
So you heard my point earlier, but I don't want to belabor that. All I'm getting at is we're seeing a massive backlash, and we know the feds, going to your point, did not indict Trump on these same, as you say, non-issue Mickey Mouse garbage. And so I guess I'm trying to just read minds here, but I just don't see how such an obviously explosive decision was made for the first time in U.S. history. And I think we can probably chalk it up just to the bubble that he's in New York City. But how do you see this as a citizen unfolding? And then I'd like you to get into all the other facets you'd like to, Mr. Dershowitz.
Well, I don't think it's necessarily just the bubble. I think he wants to be reelected. He made a promise. He promised he would get Trump. And if he doesn't get Trump, he loses his reelection. He has gotten contributions. We know reportedly he got $500,000 from George Soros. And whether he got a call from Soros or just anticipated that Soros might cut back on his contributions if he doesn't do it, this can't be based on objective legal standards. Nobody else would ever be indicted for these kinds of absurd non-crimes. So plainly, he succumbed to pressure. He was pressured by his 2 former assistant district attorneys, one of whom wrote a book, saying that they ought to go after Trump. But he resisted that pressure initially, and then he succumbed to it. So I don't know whether he got pressured from other people as well, but this is not a righteous, objective, neutral application of the law and the facts. This is something very different. Keep an open mind until you see the indictment. Remember, the indictment hasn't been leaked. The fact of the indictment has been leaked. And by the way, the district attorney, Bragg, should be investigating who leaked it. It's in his building. It's under his nose. It's in his watch. And is he investigating who made the leak? A leak in New York by grand jurors or by members of Bragg's staff constitutes a Class E felony subject to 1 year to 5 years in prison. So I think it's important to know whether Bragg is in fact investigating this leak.
Yeah, Professor, can you describe for people, I know the courts have sadly not meaningfully enforced it in my view, but that there is a limit on prosecutorial discretion in the Constitution, colloquially known as selective prosecution under the First Amendment, enforceable through the 14th Amendment against the states. Do you think President Trump has a grounds to bring a motion to dismiss for selective prosecution? And can you explain to folks out there what that is and what that entails, and that our Constitution does in fact have limits on this kind of excess of prosecutorial discretion?
Oh, there's no question that there are constitutional limits. Selective prosecution is a hard case to make. This one is so obvious that any court should see through it. Nobody has ever been prosecuted or will ever be prosecuted in the future for doing anything like this. If the indictment is what we think it is, we're not absolutely positive. So we have to wait and see. There are also other limitations, ethical limitations. For example, a prosecutor can't put a witness on the stand who he knows or reasonably suspects may be lying. And Michael Cohen, my God, if the word liar appears in the dictionary, Michael Cohen's, I mean, he's the man who has lied to his lawyers, lied to the federal authorities, lied to state authorities. And I'll tell you a recent interesting vignette involving me. So his lawyers have now said, oh yeah, he was a liar in the past. He lied to everybody, but suddenly God has come down to him, lightning has struck, and he's suddenly turned into complete truth teller. Well, 2 days ago, he did a tweet about me, which constituted a defamatory lie. He suggested that I was on Jeffrey Epstein's island with underage girls. Obviously, that never happened. The one person who accused me is now recanted and basically said, she may have mistaken me for somebody else. Nobody has ever accused me. Michael Cohen decided to lie about me, and I'm going to sue him. And so this will be something that can be used in cross-examination. And then the question that if he takes the witness stand, he'll be asked, you say you started telling the truth, but you just lied about Alan Dershowitz. You know he wasn't on Epstein's island. You know he's never had sex with an underage girl. You just got mad at him because he called you a liar. So you made up a story about him. So you're still lying, right? How is he going to get around that? So I don't think that Bragg can really put Michael Cohen on the witness stand. If he does, he really subjects his bar card to some kind of a sanction. Lawyers have to only put witnesses on the stand who they honestly believe are going to tell the truth. That's part of the sacred obligation of a lawyer, something I've complied with for 60 years. Sometimes my clients don't like it when I say, no, I'm not putting you on the witness stand. I cannot credibly believe that you're necessarily going to tell the whole truth. And so Bragg has to be applying an even higher standard as a prosecutor. So he has really two alternatives. One, he can risk his bar card by putting Cohen on the witness stand, which would be a mistake, or he can try to make the case around Cohen, use people other than Cohen to try to prove what Cohen would otherwise prove. He may try to do that, but I suspect Cohen will be called as a witness, will be devastated on cross-examination, and then there'll be questions about Bragg's ethics.
In the same capacity, you mentioned that there are limitations on a grand jury, even though the U.S. Supreme Court, in my view, has watered those down. But one of them that still exists is a prosecutor cannot knowingly suborn perjury or things like that. Do you think there's the possibility that perjured testimony may have occurred in front of this grand jury, including by Cohen?
I do think so, and I think it was also suppression of evidence. Remember that Costello was not called as a witness. Costello, who was Cohen's lawyer, he was not called as a witness. Obviously, Bragg wanted to keep him from the jury, but he volunteered, and he essentially burst into the grand jury room and said, you're going to have to listen to me. And then he testified that the hundreds of emails that he had sent to the DA to show to the grand jury were never shown to the grand jury. So I think there'll be a motion as well for suppression of exculpatory evidence in front of the grand jury. And we'll see whether or not there's also suppression of evidence under the Brady principle that should have been turned over and should be turned over to the defense. This is only the beginning of what will be, as you say, a very monumental case. When I think of the cases in American history, and I've written a book about that, America on Trial, going through all the great cases in American history, this comes close to the trial of Aaron Burr, the former vice president keeps on giving. And so if I'm a smart prosecutor, I don't go near Michael Cohen. But, then the juries will wonder, getting back to Burr for a second, Burr, as you know, killed Hamilton in a duel, but he wasn't prosecuted for that. He was actually sitting vice president when that happened, but he was prosecuted years later for treason. He tried to get a verdict of not guilty. The jury returned a verdict of not proven using the Scottish system. He objected to that, and the judge, who was John Marshall, the great Chief Justice of the United States, said, no, you're going to have to be satisfied with the verdict of not proven. But that trial, and then I would say some of the McCarthy trials, some of the civil rights trials, are the greatest trials in American history. The Rosenberg trial, there are so many. This is going to rank among them if it ever gets to trial. It's a strong possibility. It won't get to trial. It'll be dismissed on statute of limitations or other grounds, but it might get the trial. And if it gets the trial in Manhattan, he probably will be convicted. And then it'll have to go up to appellate courts. And appellate judges in New York are also elected. And so it may have to wait to get into the federal courts and up to the Supreme Court. But my prediction is, in the end, if the indictment is what we think it is, it will not survive.
There has been some talk, Professor, about the possibility of issuing a gag order. That I see this as misuse of bail authority, a violation of First Amendment principles. Can you just tell people why there's constitutional limits on such a gag order, why it should not apply here, and what's the risk that the political pressure in New York leads a judge to issue that kind of gag order?
It's possible. Gag orders like this have been issued in the past. They are, in my view, unconstitutional. We have to take seriously the notion that every American is presumed innocent unless and until they're found guilty by a jury. And innocent people can't be denied their First Amendment rights. By the way, it's not only Trump's First Amendment rights, it's the First Amendment right of everybody to listen to what Trump has had to say. And there are millions of people out there who want to hear him say what he has to say. And so I don't think it would be constitutional to impose a gag order or a travel restriction if he's running for president. But, judges have a lot of discretion, and a lot of judges have made a lot of mistakes about bail conditions. And so I hope that when a judge makes the decision, he'll think more about the Constitution than about what his friends will say about his decision.
In the context of Michael Cohen, for a witness who has as you note, the extraordinarily poor track record that he does in making contradictory statements, by his own admission, a self-confessed fraudster, by his own admission, a self-confessed liar, by obvious implication, a perjurer. What are the if you were defending the president? How much would you make the reliability or lack thereof of Michael Cohen a key part of the trial strategy?
Oh, it's a very key part of the strategy. When prosecutors put on witnesses that lie and that lie to the juries see through that and don't like it. Look, people credit me and others for winning the O.J. Simpson case. We didn't win the O.J. Simpson case. The prosecutors lost the O.J. Simpson case by putting on lying witnesses, by putting on police officers who tampered with the evidence. The jurors told us that afterward. And so the greatest gift to Donald Trump would be Michael Cohen. We're seeing the play Hamlet. Where's the prince? We don't see Hamlet. He's the central character in this thing. And he's not testifying. And so they're going to have to try to explain that. This is not going to be an easy case on the merits for Bragg. It may be an easy case because if it's held in Manhattan. If it's held anywhere else, I think it'll be a hard case for him.
Now, do you think that people have a right, of course, to an impartial jury? As you note, that's a very difficult thing to come by in New York City if your name is President Donald John Trump. What can you remind people? What are your constitutional rights, and what would a good judge do to try to find an impartial jury in Manhattan?
Well, I think it would be an impossible task, but he'd have to give the defense an enormous amount of leeway in questioning jurors. And let's assume you could get 12 jurors who never heard of Donald Trump. What kind of people would they be if they never heard of Donald Trump? Or 12 people who say they have no opinion on Donald Trump. There's one word for that, and that's liars. A lot of potential jurors lie because they want to get on the jury. Everybody wants to be on the jury in the most historic case in modern American history. So you're going to get a lot of people lying about a lot of things in order to get on the jury. I have to tell you, I think it's an impossible job to try to get a fair jury in Manhattan. And I would hope that judges would see that. Now, the motion to get a change of venue is sometimes appealable if that's denied. So it might get to a court of appeals fairly quickly, and a court of appeals might send the case to a different borough or to upstate New York. But we'll see if judges have the courage to do the right thing here. The right thing is to get the case out of Manhattan.
Professor Dershowitz, what about the timing? In other words, the public has a right to a speedy trial. Trump has a right to a speedy trial, but it may not be in the interest of justice to have a too speedy trial in this case. What do you think the timing is if the case actually ultimately proceeds to a jury trial, if it gets past motions to dismiss and things of that nature? What do you think the timing will be of an actual jury trial in this case?
Hard to believe that there could be a jury trial in this case in this calendar year. I would think that it will occur during the election year, which will make things even more difficult. But the timing was up to Bragg. I think the speedy trial and statute of limitations issues have already expired. I mean, these events occurred 7 years ago. Can he get a fair trial based on the passage of time? And don't statutes of limitations have to be enforced fairly? But I do think that with motions, with possible appeals that could be made of motions, that we're probably thinking about 2024.
In terms of the issues concerning the political weaponization and selective prosecution, does this potentially open the door to Republican prosecutors and say some small county somewhere in the country deciding, well, we'll indict Hillary Clinton now. We'll indict, we'll find something to indict Barack Obama on. We'll indict Hunter Biden. We'll indict Joe Biden. What is the risk of that door has now been opened by this prosecution?
Oh, I think the risk is considerable. In America, we have seen over and over again tit-for-tat politics, and anything the Democrats do, the Republicans do, and vice versa. And I do think that we will see more political charges, and we'll see the bar reduced. It used to be the case that you understand that if a person is running for office, you must have a very high bar to prosecute. It has to be a clear case. This, if the indictment is what we think it is, will have violated that rule and lowered the bar, and that lowering of the bar will apply to Republicans, to Democrats, and for everybody. And this is a case that endangers all of our freedoms. If you can bring a criminal case on the basis of this kind of flimsy evidence and law, that means nobody is safe. Justice Jackson once said, excuse me, that any prosecutor can rummage through the statute books and find something to pin on somebody, and that's not the way American law should apply. And that rule, too, has been violated by yesterday's actions.
Yeah, it very much feels like a Berea prosecution. Show me the man and I'll find you the crime. One thing that's always stood out to me throughout this process is you identify in your book, Get Trump, and have talked about being problematic from the get-go, is usually sometimes when you have a high-profile political person saying they're going to go after somebody, it's for something that's already happened in a clear criminal context, like, oh, I'm going to go prosecute Enron, or I'm going to go prosecute the white collar, or whatever. Rare do you see, I'm going to go prosecute that guy. I'm not sure on what yet, but I'm just going to go get that guy. The old famous Berea statement to Stalin, show me the man and I'll find you the crime. To some degree, to what degree does this raise issues of due process? That if we see the indictment and we see laws being applied in ways that could not have been really on fair notice of most people, as you pointed out very articulately at the beginning, non-disclosure agreements are done all the time. Nobody puts them in their public disclosure later or their internal documents. Oh, by the way, here's my hush money payment. I mean, it defeats the whole purpose of a non-disclosure agreement. Now, all of a sudden, all those people could be criminally prosecuted all across America. How much is there an issue of fair notice and due process that might come up in these proceedings as well?
Well, there's no question. There is an issue of fair notice, and there is an issue of what the law calls lenity. When you have ambiguous statutes, they have to be resolved in favor of the defendant. It all goes into the concept of targeting, of Get Trump, of due process violations, of selective prosecution. All of these will be raised. Some of them are harder than others to get a judicial relief on them, but they are all part of also the court of public opinion. For example, the governments can argue the statute of limitations didn't get told because he was out of the state, meaning you couldn't indict him if he was in Washington, D.C., but they indicted him when he was out of the state. So that gives the lie to the notion that they couldn't have indicted him any day over the past 7 years. And statute of limitations of misdemeanors, 2 years, felony, 5 years. Those are long expired. Why didn't they indict him while he was outside of the state, or even while he was in the state, which he came to from time to time? And the reason is obvious. Prosecutors looked at the case and they said there's nothing here. And so they didn't indict him, and now they decided to change that 7 years later. That should not survive statute of limitations scrutiny, but it might, because the New York Court of Appeals had a weird decision about how you count the days being out of the state. But I don't think that's consistent with what the statute of limitations, which was enacted by the legislature, had in mind.
And can you explain for folks that the statute of limitations isn't just like some little procedural aspect? Sometimes we hear, technicalities, and people use that excuse for how criminal defendants escape as they view justice. In fact, these are constitutional rights and liberties meant to impose fair notice is a critical component of what statute of limitations is all about. And that the rule of lenity, as you mentioned, is about protecting against the defendant being wrongfully prosecuted in a way they couldn't fairly anticipate and how we interpret the laws. Could you remind folks that, what other people call technicalities are the core to constitutional liberty in America?
Well, my life has been a life of trying to impose what other people think are technicalities, and I think are the essence of what makes America the greatest democracy in the world, that we have rules of law, and those rules of law have to be enforced fairly and equally, and statutes of limitations are part of them. Look, we're seeing a challenge to statute of limitations. The Me Too movement got many states to eliminate statutes of limitations for rape and other sexual crimes, and that has created major problems because memories disappear, witnesses disappear, and statutes of limitations have to be taken seriously. And I don't think any crime other than perhaps murder should be prosecuted beyond a certain period of time, 5 years, something like that. But they certainly shouldn't be extended after the statute of limitations has expired. The Supreme Court has said that would be unconstitutional. So there is a constitutional dimension to statute of limitations.
Have you been surprised? I've been surprised to some degree at many of my friends on the left, in particular, but not limited to it, within the legal world, have, in my view, abandoned a lot of their principles, either because of political pressure or because of just like Trump derangement syndrome and the rest. Have you been surprised at seeing that? And are you, while you predicted it and get Trump and forecast this is where the world was going, are you still surprised that we're actually here? We're to this point.
I am. I'm disappointed. In my previous book, The Price of Principle, I talked about how so many civil libertarians, people like my former colleague Lawrence Tribe, and the ACLU are prepared to give up on the Constitution in order to get Trump. And I've had people say that to me. We're prepared to do anything, distort any constitutional provision, ignore any rule of law if we can get Trump. And that's why the subtitle for my book, Get Trump, is The Threat to Civil Liberties, Due Process, and Our Constitutional Rule of Law. It's not only a threat to Trump. It's not only a threat to people who get indicted. It's a threat to have the rule of law subordinated to the preference of politics. And I think we're seeing more and more and more of that. There's less respect for the Constitution. And people on the hard left, particularly in the woke movement, have said over and over again, we don't care about freedom of speech. We don't care about due process. We know the truth. We know if you're a man who's been accused by a woman, you have to be guilty. What do you need a trial for? What do you need due process? We know if you're somebody who makes statements that are sexist or racist, there's no room for that under our First Amendment. We don't need to hear your point of view. That's what happened in Stanford when a group of people from the National Lawyers Guild organized an attempt to try to shut down and silence a federal judge whose views they disagreed with. National Lawyers Guild is going to do that all over the country at 100 law schools where they have organizations. And so we have to fight back for every one of our amendments. Look, if I were writing the Bill of Rights, I might not put the Second Amendment in, certainly not in the ambiguous terms that it's there today, but it's there. And we have to fight to preserve it, just like we have to fight to preserve the Fifth Amendment and the First Amendment. That's the basis of our democracy. The Bill of Rights is a constraint on majority rule, and we have to keep that viable. And we're not doing that. We're allowing partisan political preferences to prevail over the Constitution.